Well, good afternoon, everybody. My name is Matt Godson. It's my pleasure to welcome you here to this afternoon's webinar entitled Dancing Around Landmines, Hot Topics in US and Canadian Sanctions. Before I turn things over to our panelists for this afternoon, I have a little bit of housekeeping to announce to you. Firstly, that there will be a Q&A session at the end of this presentation. If you wish to pose a question to the panelists, I would advise you to use the question panel, which is in the GoToWebinar panel to the right of your screen. You'll see a couple of messages from me in the chat box, so you'll be able to find that in case it's not clear to you. In addition, this webinar is being recorded. Everybody on this call, as well as people that can't make it, will automatically receive within 24 hours a link which will enable you to both download the presentation, the slides, as well as a copy of the recording of this webinar. That's pretty much all from me right now until the Q&A portion. At this point, I would like to hand over to Scott Mabry to introduce himself and his panelists for the presentation. Scott, over to you.
Thanks, Matt. This is Scott Mayberry. I'm partner at Shepherd Mullen Richter and Hampton in Washington, D.C. My co-panelists are Dan Chapman. He's Chief Compliance Officer and Counsel at Parker Drilling Company. And Vince DeRose. He's a partner at Borden Ladner Gervais in Canada. And those, just so you understand the hierarchy on this panel, I'm the old guy. Which means that I've forgotten more than either of these guys knows about sanctions. And when I say that, I mean that literally. That is, I forget a lot of things. So listen to what they have to say, and they'll tell you what's right about sanctions. Matt, could we go to slide 3? We're going to talk about an introduction to U.S. sanctions and Canadian sanctions, and then what's on our minds in terms of recent developments in both. We'll talk a little bit about how some compliance with sanctions is done, and then we'd like to take questions at the end. Slide 4, please. So this is the introduction to U.S. economic sanctions. And as you can see from the graphic there, a lot of what the United States does in conducting its sanctions policy is it freezes assets. And as you'll see, that fits into a larger program of all kinds of different sanctions that the United States is capable of imposing, some of which are more effective and efficient than others. So next slide, please. A way to think about sanctions that is somewhat different from the way we think about export controls. A lot of times, and this is review for many of you, but a lot of us come from the export control world, and we're thinking about where we can send things and where we can't. Sanctions is a little bit like that, but it's also a little bit different. It does something that export controls cannot do, and that is that it controls and regulates transactions. That means that it goes to what we do and who we can do it with, not as much or not just where we can go or where we can send things. There's another interesting aspect of sanctions, which is the target of a sanction might be an individual or an entity or a vessel or a country or a practice. So it's not just against certain places or things. Typically, our sanctions are based on U.S. foreign policy and national security considerations. And as everyone on this phone knows, that those can be as varied as the various experiences that we have in the world, and they can change very rapidly. And that's the thing to remember about sanctions, and the thing that makes it such an interesting area of the practice of law, but also hard to keep up with, and that is that they change all the time. So this is the slide that I was supposed to turn over to Dan. So Dan, why don't we let you take it from the middle of slide 5.
Well, everyone, thanks, Scott. He stole my thunder in my introduction, but I'm glad to to cover basically the same. I want to reiterate what Scott said. Many countries impose economic sanctions, but we're focusing on the U.S. component right now. And these sanctions are imposed against other. They're imposed against other countries, imposed against specific persons, and imposed against specific activities. But around the world and in the U.S., Economic sanctions generally follow a similar formula. They forbid directly engaging in or facilitating others engaging in prohibited dealings with sanctioned countries, governments, persons, or activities. Now, I'll talk later in this presentation about what facilitation is, but just as a place marker, I'll state that it's an expansive and almost indefinable legal term that has a meaning similar to enable. And sometimes when you think about whether or not an activity is facilitation, you may want to think of a chain of events. And if it is somehow is earlier in that chain of events, there's a risk that it might be characterized as facilitation. But we'll talk about that in a little more detail in a few minutes. Now, economic sanctions function by a number of methods. In addition to prohibiting certain types of specific transactions and the prohibition on facilitation that Scott mentioned, and also I'll go ahead and say in a closely related concept of an export of services, because Scott will cover export of services in a few minutes, but I think that in many cases what is called facilitation and what's called an export of services can cover the same activity. But we'll distinguish that again in a few minutes. Economic sanctions also prohibit certain types of imports and exports, and they function by freezing assets. Okay, in other words, if you come into possession of an asset for which a sanctioned party has an interest, if you're subject to that sanctions regime, may have a legal obligation to freeze that asset. In other words, to do what many of us would think a government regulator would do. You have an obligation to set that asset aside, report it, and freeze that asset and not turn it over to the sanctioned entity or individual. Now, economic sanctions can be divided, I think, into three groups. In terms of what is a prohibited dealing. You have the country-based groups, which can be comprehensive or selective. The more comprehensive programs are like the sanctions programs implemented against Cuba and now Iran. And also you could throw in there Syria, a more recent addition. You also have more selective programs, such as the country-based programs against Russia, which also incorporate two other types of prohibited dealings. So the second and third types of prohibited dealings are targeted programs which really go after a specific type of activity. So, for example, Arctic drilling in connection with the Russian sanctions. Or they go after individuals or entities. In other words, these list-based programs target specific persons, entities, or government agencies. And many of these programs, I think the emerging trend over the last 10 years is a much more high reliance on list-based programs. And speaking of list-based programs, I'll go ahead and turn it back over to Scott, who can tell you a little bit more about specially designated nationals, which is the primary U.S. list-based program.
So we're on slide 8, and it's unlawful for anybody subject to U.S. law to do any business whatsoever with a so-called specially designated national. So any person that the U.S. government has determined is acting in a manner that is inconsistent with U.S. foreign policy and national security goals can be designated without due process of law as a specially designated national. So if you go to the SDN list, you'll see lots of specially designated terrorists and terrorist financiers, also narco-traffickers, also people interfering with the peace process in Kosovo, and a bunch of regime members in Zimbabwe. So really anybody can be designated. And as I say, there's not much process associated with designation, and the consequence is that you and I are prohibited from doing any business with that person. One thing to remember, and I'm sure you all have come across this from one time to another, many specially designated nationals reside in the United States or in Canada or in Mexico. So it's not enough to assume that since you're doing business in a safe country that you're not doing business with a specially designated national. You have to ask yourself that question and do the right diligence to keep from doing so. Slide 9 is next, and that goes to the point that I just glossed over quickly, which is if you're subject to U.S. law, you have to comply. So that's true, of course, if you're a U.S. citizen or permanent resident, wherever you're located. So, for example, it's unlawful to travel to Cuba and engage in financial transactions in Cuba, even if you're traveling there from Mexico or Spain. It also covers U.S. companies and their branches all over the world. And interestingly, it covers persons in the United States regardless of their nationality. So if there's a Spanish person in the United States and they're doing business with Iran while sitting in the Waldorf Astoria Hotel in New York, then they are covered by the sanctions and can't do that. By the way, the Cuba and Iran sanctions both also reach non-U.S. entities owned or controlled by a U.S. person, which didn't used to be the case for the Iran sanctions until some recent revisions of the sanction. Next slide. There's also a very interesting emerging concept called the causation. That is, any person who causes another to violate the sanctions can be held liable for the sanctions, and that's true even of a non-U.S. person. One of the theories, not the only one, but one of the theories of jurisdiction in the recent BNP Paribas case was this causing a violation. This was a non-U.S. bank that, by virtue of stripping out information from the SWIFT codes for various wire transfers involving parties in sanctioned countries, enabled money to be transferred throughout the U.S. banking system, causing a bunch of U.S. banks to inadvertently violate the sanctions. And so, as I say, one of the theories on which BNP Paribas was whacked in that case was that they caused the U.S. financial system to commit these violations. Very important thing to keep in mind, and it's going to be interesting to see how that concept develops. The next thing I want to talk about is the prohibition on the export of services, and this is a prohibition against the provision of a service anywhere where the result of that service is received by the sanctioned party. And I kind of say result sometimes more often than I say benefit, because a lot of times you'll be looking at a sanctions problem and a service will be provided, and you'll hear people wanting to get out of the analysis by saying, well, nobody really benefited from this service. And that's not the way OFAC, our regulator, thinks about this stuff. So try not to think of it as a benefit being provided, but as the result of that service or the effect of that service being received by the sanctioned person or in the sanctioned country. And with that, I'm going to turn it over to Dan for slide 12.
Thanks, Scott. Building off of what you just mentioned about export of services, I will go ahead and let the listeners know that quite often people will use the term facilitation when they're actually referring to the causation theory or the export of services concept. That's not technically correct, but I just want to alert people that sometimes that occurs when people are talking colloquially about U.S. economic sanctions. But more specifically, the concept of facilitation is limited to support for any activity that would be prohibited if it were performed by a person subject to U.S. economic sanctions. Now, the concept of facilitation is broadly interpreted, but there's very little guidance out there. Explicit language is found in the Burma, the Iranian, and the Sudanese sanctions programs, or the old Burmese programs for which you now have a general license. And although it's limited to those programs, or really spelled out in those programs, OFAC typically and pragmatically understands that the concept of facilitation applies to other sanctions programs. So just because the concept of facilitation isn't written into a particular set of regulations, if you're dealing with OFAC, you should start from the assumption that OFAC's going to read the concept of facilitation into your applicable sanctions program. Now, as I mentioned earlier, the concept of facilitation is really similar to the word enable. And the best way to understand what facilitation covers is really to look at those regulations and take a look at the examples that are provided. So, for example, making referrals to foreign persons not subject to economic sanctions, what that means is if you, let's say you're in the U.S. and someone calls you up and asks you if you can do a deal in Cuba and you say, no, I can't, but I know of a foreign company who can. Here's their name. If you do that, that's facilitation, and that is prohibited. Changing your own practices or procedures to allow others to engage in prohibited transactions is also an example of facilitation. So if you work for a large international organization and they wish to do business with an individual who is sanctioned by the U.S. government, and the company's approval process would be such that the approval for doing that business would have to come through the U.S. regional headquarters. If a U.S. person changes that policy so that that referral process occurs, that approval process occurs outside the United States, that change is illegal facilitation if it results in a otherwise prohibited transaction. So changing your internal procedures to allow non-U.S. persons or persons not subject to U.S. jurisdiction to engage in a prohibited dealing is not permitted because it is facilitation. Providing business legal standing or support of a prohibited transaction is illegal facilitation. Brokering, guaranteeing, incurring financial risk, or providing insurance for sanctioned entities is, again, facilitation. Almost any form of assistance rendered by a person subject to U.S. economic sanctions in support of a sanctioned transaction will constitute facilitation. It's a very broad and widely used concept by OFAC in its enforcement activities. So moving on, I do want to mention some information about penalties, which is covered on the next slide. Now, the penalties will differ based on the underlying statutory regime, but in general, and I am speaking in general, the penalties for violations of U.S. economic sanctions for civil fines range up to about $250,000 or twice the amount of the underlying transaction for each violation, whichever is higher. Now, OFAC has a very interesting way of counting violations. So I caution anyone who thinks, well, I only have one transaction. They may find, in connection with one transaction, a violation for facilitation. They may find a violation for each of the separate U.S. individuals or entities involved. So I caution people to think, well, it's only a $250,000 risk unless the underlying transaction is worth more than $125,000. So I do want to caution people and let you know that the magnitude could be significantly higher. On the other hand, the magnitude is very clearly higher if you're dealing with willful violations that result in criminal penalties. Those fines can range up to $20 million per count and do often result in the risk of imprisonment. Now, imprisonment for economic sanctions violations is not used frequently, but it is always a threat, and it is a very frequently used leverage point for OFAC regulators when they talk about referring a matter to the U.S. Department of Justice for enforcement. And of course, the DOJ would be the U.S. government regulator that would be able to take criminal action. So with that, I would like to turn it over for a discussion of Canadian economic sanctions on the next slide.
Thank you, Dan. We can actually go to the next slide. Let me start by saying this. If I were to be giving this talk this time last year, I probably would have started off with a caveat saying that the Canadian government does not aggressively enforce Canadian sanctions. In the 22 years leading up to 2014, there were no criminal convictions under Canadian sanction law. So the sanctions existed, but they, by and large, were not enforced through criminal prosecution. That has changed this year. The Royal Canadian Mounted Police, or the RCMP, which is the enforcement arm of the government with respect to sanctions, has successfully charged and convicted under Canadian sanctions and has a large number of investigations underway. So in Canada, we've really seen a bit of a sea change with respect to sanctions, and it means that Canadians and Canadian companies in particular that export abroad are looking at sanctions laws with a heightened interest with respect to compliance. The range of measures are actually very similar to what has already been described by Scott and Dan. The most low level of sanctions may place travel bans, or diplomatic contacts would be limited. There are also freezing of property, freezing of assets, and restriction or prohibition of trade. And I'll mention it in the slide to come, but ranging from comprehensive bans with countries such as North Korea and Iran, right to selective bans. If we can go to the next slide. One fundamental difference between Canadian and American law is the extent to which Canadian laws are not extraterritorial in their application as compared to what Scott has already described. Canadian sanctions laws only apply to persons, and the phrase persons includes corporations, living in Canada, so whether they are Canadian or whether they are foreign, if they are physically located in Canada, the sanctions apply to them. And to all Canadians outside of Canada, that includes Canadian corporations. There are no circumstances where Canadian sanctions laws would apply to non-Canadian entities outside of Canada. So again, that's one fundamental difference. If we can go to the next slide. In Canada, we do not have the equivalent of OFAC. We have a number of legislative acts which impose different aspects of the sanctions regime. Some are governed by the Department of Foreign Affairs, Trade and Development, while others are the Department of Justice. And all of them are criminally enforced by the Royal Canadian Mounted Police, or the RCMP, with the assistance of Canadian Border Services Agency. In terms of the 5 principal statutes, the sole purpose of that act is to implement UN Security Council sanctions. And it is by a right. If the UN Security Council imposes sanctions, then Canada will automatically issue regulations under the United Nations Act. The Special Economic Measures Act is then used to supplement those sanctions which are either under the UN Act but Canada feels have not gone far enough. So, for example, sanctions against Iran, or alternatively where the UN has not imposed sanctions but Canada feels that sanctions are required. Both the UN Act and the Special Economic Measures Act are governed and looked after by our Department of Foreign Affairs. Our Criminal Code of Canada, which is looked after by the Department of Justice, does also impose our equivalent of the SDN list, but I think in fairness I would describe it as SDN light. It is focused on terrorism expressly, and so in terms of the broader group of companies that Scott described that are added to the SDN list if they are seen to be broadly acting in an adverse manner to U.S. foreign policy, the criminal code really focuses on terrorist groups and known terrorists. The fourth act, which is, I think, strictly speaking, not sanctions laws, freezing assets of corrupt foreign officials act. This is an act whereby a foreign state can, by diplomatic request, ask Canada to freeze the assets of its own foreign, of its own officials, its own public officials. So this was, for instance, recently utilized in the Ukraine, where the new government, by diplomatic note, asked Canada to freeze the assets of certain former public officials. And in that case, it had the same effect. as sanctions in that it's a complete freezing, but it's a slightly different process. Finally, the Export and Import Permits Act, which is our controlled goods regime, but in there is also an area controlled list. Currently, we have Belarus and North Korea on that list, where it is tantamount to a comprehensive sanctions. If we can go to the next slide.
And
so, yes.
Yeah, go ahead.
And as I've mentioned, we have sanctions from North Korea, Belarus. Roddy, you talk about that programmatic, which again I've described as terrorists. If we just go to the last slide. And just as it's coming up, I can start to describe. The next slide sets out the penalties. There we go. And you'll see that first of all, there are both administrative monetary penalties. That's at the bottom. Quite frankly, they are extremely modest by comparison to what you are used to. And it is something that is used for very minor offenses. But in terms of the criminal convictions, in Canada, the government can proceed both by summary or by indictment. And what is particularly what I want to note is that on an indictment, it is an unlimited fine, potentially, from the intent of the lines in the U.S. It is notionally unlimited in Canada, although we have not yet seen fines in the range that you have seen in the U.S., although we certainly expect it to grow rapidly. So with that, I'm going to turn it back over to Dan and Scott.
So thanks, Vince. Matt, can you go to slide 21? The first recent development we'll talk about the Iran sanctions. Right there is the list of countries that are negotiating with Iran to reach a plan to ensure that the nuclear program there will be peaceful. It's a shocking development. There's been more development there in the last year than I would have ever expected. Next slide tells us a little bit about the timing and what's happening. What's happening now is we're in between the beginning of the negotiations and some kind of comprehensive deal. So we've got this joint plan of action, JPOA. And so there have been some limits placed on the nuclear program, and then we in turn and our partners have committed to provide certain sanctions relief. Next slide shows the areas of that relief: petrochemical, crude, auto industry, gold and precious metals, and civil aviation. It ends in a couple of ways, and by that time, the parties have committed to having a comprehensive agreement. At that time, the agreement then will take place, and there will be a whole separate set of sanctions changes. And so look out for what might happen. It's not certain that they're going to reach an agreement during that time, but the aim is to have a comprehensive agreement by November 24th. The outline of the limitations that Iran has placed on its own nuclear program under the JPOA are listed on slide 24. I think I'd like to just go past that slide quickly to try to get us closer back on time and have Vince tell us a little bit about the Canadian sanctions against Iran specifically on slide 25, please.
Yeah, and I can be very quick. Canada's had sanctions in place since 2010, comprehensive sanctions since 2013, if you flip the slide. Canada has not been involved in the P5+1 discussions, and all public statements from Canada has been that while these negotiations are going on, it is watching it with interest, but it will continue to maintain the full force of sanctions against Iran. So Canada's not at the table. We aren't discussing. The official public position is that Canada will maintain its sanctions regardless of what the P5+1 does. I think the pragmatic reality of it is that if things evolve in a beneficial way with the P5+1, Canada will follow in some manner. So I'll turn it back to you, Scott, with respect to sanctions regarding Ukraine.
Okay, so the other major development we'd like to talk about are these Russia sanctions, and the first thing that happened was that the United States blocked the property of specific individuals and entities. We've continued to do that. You've seen the headlines talking about who and what, so I won't try to go through the specific targets of the sanctions, but you'll see that there's been a focus on these three sectors: financial, energy, and defense. Another very interesting development is in the spring, very close to each other, both the U.S. Department of Commerce, Bureau of Industry and Security, and the U.S. Department of State, Directorate of Defense Trade Controls, imposed a suspension on export licensing to Russia. And what the policy is a general policy of denial for exports to those countries, particularly of focusing on these sectors, but not exclusively. In fact, the policy is a blanket policy of a general policy of denial. So those policies remain in place, and it's very hard to get a license to export anything to Russia now. Next slide, please.
With respect to the Canadian sanctions, Canada has imposed sanctions against both Russia and Ukraine. On this slide, it just sets out so that you have the numbers. For the Ukraine, the individuals and entities, it is effectively a complete freeze, a complete ban on any form of trade with those individuals or entity. With respect to Russia, if we can turn to the next slide, what Canada has done is in what they refer to as three schedules. Schedule 1, those individuals listed, and again, just from the last slide, it's 66 individuals, 34 entities on Schedule 1. It is a total freeze or a complete ban on any economic activity, service, goods, or support provided to those people or entities. With respect to Schedule 2 and 3, these list certain financial institutions and impose limits on certain types of debt and equity financing. And this is a difference between the way that Canada and the US and the EU have approached Russian sanctions. Canada has not directly targeted the oil and gas sectors, but it has tried to target certain financial institutions by imposing pretty significant limits on the manner in which Canadians can provide any type of debt or equity financing. So our focus has been on banking as opposed to oil and gas. I'll turn it back over to you, Scott, for the EU sanctions on the next slide.
So what the EU has done is something even different from the United States and Canada, and that is to first put a prohibition on the export of dual-use goods and technology for military use in Russia, and also put a prohibition on related services. So not only can you not export dual-use goods to Russia if you're subject to the EU sanctions, you also can't provide services related to that. You also, there's a focus on oil exploration and production, and also on insurance and reinsurance for any goods on the the military list, which is the EU's equivalent to the USML. There have also been some attempts to restrict access by Russia to EU capital markets. So both anybody, a national in an EU country and a company in the EU is prohibited from lending money to the 5 Russian banks that are state-owned, the 5 top ones. And then there have been, as in the United States, some designations of individuals, and by designation we mean a similar process to the specially designated national list designation process, whereby the EU has named persons in Russia or associated with the Russian regime for whom they have imposed an asset freeze and other related sanctions. So that's a little bit of a setting of the stage of the EU sanctions. And then I think, Dan, would you like to say a little bit about dealing with these Russian sanctions from a practical point of view?
Sure, I'd be glad to. I think it's well, let me just start by saying all of the general concepts that you thought you would find in an economic sanctions program are muddled in the Russian program. You have export controls that are based on designations and categories that were normally in nomenclature that's normally found in customs import rules. You have a whole new set of rules that apply to designated parties that is a subset of the SDN list in many people's minds. It's separate. It's called the SSI list, but you can't do business with these people for the following activities, where most of the time when you're dealing with SDNs, you just can't do business with these people, period. So the key to dealing with the Russian sanctions is to stop, take a look at the regime, make no assumptions, and try to understand it. Now, when I went through that process, I looked at the overall regulatory regimes from the EU and the US and Canada, and you can really group things into three buckets. The first bucket is the traditional list-based SDN type blocking. So the designated parties that you just can't do any type of business with. These are typically people with military connections, or they're very senior in the Russian government. And that applies on both sides of the Atlantic. Now, you also have this second bucket. The second bucket is you can't do this type of business with these individuals or entities. The U.S. version is called the SSI list, but that's where you have the restrictions on lending, financing, dealing in the equity of these legal entities, but you could sell to them, right? It's a very odd and unique bucket, and it's new, and it's only been imposed here in the Russian regime, where you have a list-based program that is subject to specific activities. I shouldn't say only here, but this is the first time that it's been used this widely. And then you have the third bucket, which is the import and export controls. Obviously, that's not the subject of this webinar, but it's worth mentioning because I think it presents a lot of difficult process-related problems for companies. So, for example, these regimes, both the U.S. regime and the EU regime, they designate particular items based on their import classifications. That's unique. Not their export controls, but they're based on import designations. They're not their ECCN, but their HTS code, their Schedule B code. You cannot export these items without a license if it relates to Arctic shale or deep water, which the definition of deep water in these sanctions regimes is different than what the industry uses. It's 500 feet versus 1,000 feet. So that, if you are in those three designated areas, you're dealing with something that's in the Arctic Circle. You're dealing with, it's related to petroleum industry, oil and gas exploration and production. If it's Arctic, it deals with shale plays, or it deals with deep water. Then you're going to need a license from either the EU or the U.S. Where it gets murky is, let's say you're not within those three designations, but you're dealing with one of those items. The U.S. regime does not require you to apply for a license. The EU regime does require you to apply for a license. So it's unique in the sense that you have a license requirement in the EU that you don't have in the U.S. if you're not within one of those three designated types of activities, you know, the non-conventional drilling, for example. But let's say you're below the Arctic. Well, if you're below the Arctic, you may still need to go and get an EU license. So the takeaway here is you've got 3 buckets. Remember those 3 buckets, and remember that the EU may require licensing for export control purposes based on customs rules or customs designations that the U.S. won't. So it's a very complex program, and I'm glad to try to answer more specific questions. But before we do that, I will go ahead and mention that Scott has kindly put on slide 32, which is appearing now, the economic sanctions version of what I view as the key principles of the U.S. federal sentencing guidelines. So as applied to economic sanctions, if you're developing a compliance program, the same sort of compliance program and key aspects that you would find, say, for an anti-bribery court program or an antitrust program, you need to have those implemented in connection with economic sanctions. And this slide, I think, properly lays them out in that context. So, Scott, if it's okay with you at this point, I think it would be great to solicit some questions from the listeners, and hopefully we'll have some answers.
Okay, that's great, gentlemen. Give me 1 second. We do have a couple of questions come in. So, firstly, for Scott, you briefly mentioned the joint plan of action negotiations between the United States and its allies in Iran. What's going to happen, in your opinion, if the November 24th deadline isn't met, for final agreement isn't met?
Well, what will happen probably is the same thing that happened when the first deadline was not met, and that is that that the parties will probably extend the deadline. And my sense is that they don't like to extend the deadlines, but they're kind of in a habit of it now. So I would fully expect. I don't have any inside information, and they may well come to a deal on the 24th and not have to do this. I fully expect, though, that they'd extend that deadline for another 6 months. I really do think that the parties do want a deal, and I don't think they're going to let that deadline stop them from doing it.
Okay, that's great. This question was for Dan. What should a company do to ensure it's not dealing with SDN, specially designated nationals, or other prohibited persons, or even companies more than half owned by them, which is prohibited in the Russian sanctions case?
Okay. I think there's let me put it this way. There's 2 buckets you just described. The listed parties and then owned parties who, I'm going to infer into your question, aren't listed. So let's start with the listed parties. I think screening is the key. And there's 3 points. There's 3 points for screening. One, you want to screen, or buckets rather, you want to screen your vendors, you want to screen your customers, and you want to screen your employees. So however you want to do that, if you have a central repository, that's a great thing to do to screen them. But you want to screen each of those buckets. Now you also want to screen them at 3 different intervals. You want to screen them at the onboarding time, so before you become a vendor or a customer. You want to screen them periodically, because the sanctions constantly change and new parties are periodically added and regimes change. And then I think you want to screen them for audit purposes. So, you know, if you're relying on your onboarding screening, it's periodically a good idea to go back and get a list of all of your vendors and screen that, because sometimes people will, or parties will slip through the onboarding process, particularly if you don't use a central repository. Now, I think when you screen, you have to look at it with more attention, I think, you used to, because you have these new types of designations or restricted or list-based programs where it's not just dealing with the party, but it's dealing with the party in a certain activity, just like the Russian programs that we talked about. So flagging and review is much more important in today's world than I think it was 2 or 3 years ago. It used to be if you had a match, you just couldn't do business with them. Today, that's not necessarily as clear-cut as it was a few years ago. So I think screening is the key for the parties that are listed. If you're talking about the owned subsidiaries, I think the only way you can really diligence that is through raising the issue with the third party, finding out who owns them, and in a practical sense, if you're a company that has 40,000 vendors, which many companies do, identifying which ones are owned by sanctioned parties can be very difficult because many of them are not going to offer that up. But you have to rely on your personnel as well and educate them. Say if this is owned by, if this vendor or this third-party customer or even your employees, if they are related to a sanctioned person or entity, you need to alert compliance and let us know. So I hope that answers your question.
Okay, our final question. In the time remaining, we're a little over, but I think we can squeeze in a final question. This one was for Vince. What does a company do when it's subject to both U.S. and Canadian law, and the laws conflict? For example, the U.S.-Cuba embargo conflicts with the Canadian statute prohibiting compliance with the U.S.-Cuba embargo. So what's an entity to do in that scenario?
It probably depends whether you're asking a U.S. attorney or a Canadian lawyer. For those of you on the phone that aren't aware, Canada has a law that is expressly created to block the U.S.-Cuban embargo. So in Canada, companies are not allowed to direct their employees or their companies to do business with Cuba because of the U.S. embargo. So in the past, when we've dealt with this, when you ask us, we say it's illegal to tell your employees not to do business with Cuba. U.S. attorneys will say best practices are that you have a manual that expressly says you cannot do business with Cuba. The pragmatic around is that you have to very carefully word your compliance manual in Canada in such a way that you are not directing the Canadians to not do business with Cuba. But most companies will then have outside of the formal direction, they will have either an understanding or a requirement that any transactions with Cuba have to go through internal checks and balances, and they will just not do business with Cuba. So there's no perfect workaround, but it's a difficult situation when it arises, and it's one that has to be carefully drafted in terms of the directions and the compliance manuals internally for your Canadian subsidiaries.
And you really need a Canadian legal counsel to solve a problem like that, so I wouldn't encourage anybody to try to do that without Vince's help.
Well, I appreciate that, Scott. I mean, we tend to do, it's quite frankly, it's a little bit artificial the way that people get around it, but the worst thing that can happen is that you just simply apply the same wording that someone like Scott has drafted you in the U.S. and Canada, and will be expressly offside of the Canadian law.
Exactly.
Okay, that's great. Now we did actually have one more question, but we are out of time. But I'm just going to assure that questioner that I will pass your question on to the panelists after this call concludes. With that said, I want to thank Scott, Vince, and Dan for your super thorough and an in-depth presentation today. I really appreciate it. I'm going to offer you the opportunity to say goodbye to the assembled company.
Thanks, everyone. Goodbye.
Thank you.
All right, wonderful. With that being said, this is Matt Godson with Momentum Events, and this concludes the webinar. As mentioned, I'm going to send everybody a link which will enable you to receive a copy of the presentation, both the audio and video, as well as download the slides. With that said, I want to wish you a very pleasant afternoon. Goodbye.